Welcome back to the deep dive. Today, we're tackling negligence. It seems simple at first glance, but it gets super complex legally. I think our listeners send in some legal study materials from the Open University, so we're going to break it all down.
It really is amazing. I mean, how a concept like negligence, which we encounter every day, has this, whole legal history and framework.
Yeah, it's not just about someone messing up, right? It's a whole system for figuring out who's responsible when things go wrong. We'll be going over landmark cases and digging into how the law actually determines who is at fault. Ready to dive in?
Absolutely, yeah. Let's unpack this.
Okay, perfect. So, to start, let's set the stage. We're talking about tort law, which basically means civil wrongs, actions that harm someone, give them a reason to sue. Negligence is a big one under tort law.
And what's so interesting is that before 1932, there was no distinct tort of negligence. So the idea was kind of there, but it didn't have the legal structure it does today. And then came along a game-changing case, Donoghue v. Stevenson.
Donoghue v. Stevenson, the snail in the ginger beer bottle case. It's a little icky, but it's a perfect illustration of duty of care, which is central to negligence. So for our listeners who maybe need a refresher, what happened?
So Mrs. Donoghue was enjoying a ginger beer that a friend had bought for her. And to her horror, she found a decomposed snail in the bottle. The bottle was opaque, so she didn't see it before. She ended up getting sick and sued the manufacturer. But back then, you couldn't just sue anyone. You needed a direct contract, which she did not have with the manufacturer.
But the court actually sided with her.
They did, and that's what made Donoghue v. Stevenson so revolutionary. It established that manufacturers do have a duty of care to consumers, even without a direct contract. So this case laid the foundation for negligence claims as we know them, and it established three core elements.
Let's break those down. First, there's duty of care. So that means someone has a legal obligation to act in a way that prevents harm to others. It's kind of like this unspoken agreement that we'll all, look out for each other.
Exactly. Then there's breach of duty, which means someone didn't act as carefully as a reasonable person would in the same situation. We'll get back to this reasonable person, which is a fascinating concept.
And lastly, there's causation. So the link between the breach of duty and the actual harm, it has to be clear that the harm was a direct result of the negligence.
Yes, precisely. Now, Donoghue v. Stevenson didn't just outline these elements. It also gave us what's called the Neighbour Principle. It's really a cornerstone of negligence law.
Okay, the Neighbor Principle. This is where it gets really interesting. So essentially, you owe a duty of care to anyone you can reasonably foresee being harmed by your actions, right? It's kind of like expanding the idea of neighbor beyond just, the person next door.
Exactly. It's not just about physical proximity, but also relationships and connections. Like, imagine a doctor and patient. Even if they've just met, there's this duty of care because the doctor's actions will directly affect the patient's well-being.
Or think about a car manufacturer. They have a duty of care to anyone who might drive or ride in their car, even if they've never met those people face to face. It's about thinking about how your actions might affect others, even indirectly.
Right. And this neighbor principle has led to some pretty fascinating legal developments. Courts have had to figure out, how far this duty of care goes, especially in situations that are new and complex.
And that's where Caparo Industries' Paelhi v. Dickman comes in. This 1990 case gave us a more structured test for figuring out duty of care in situations where it wasn't so obvious.
Yeah, the Caparo test asks three questions. First, was the harm foreseeable? Could a reasonable person predict that someone might get hurt? Second, was there a close enough relationship between the parties? That neighbor idea again.
So not just like random strangers on the street. There has to be some connection.
Exactly. And finally, is it fair, just, and reasonable to impose a duty of care? And this gives courts some flexibility to consider the bigger picture, right? Like, are we opening the floodgates for lawsuits, or is this a situation where someone really needs to be held responsible?
So Caparo brought more clarity to defining duty of care, but it didn't end there, right?
You're right. In 2018, the Supreme Court case Robinson v. Chief Constable of West Yorkshire Police kind of signaled a shift.
Ooh, a plot twist. Tell me more.
Well, this case involved an elderly woman who was injured during a police arrest.
Yeah.
And the court decided that when established principles of negligence already apply, like the duty of care owed by police during an arrest, the Caparo test, the rigid test, might not always be necessary. So they emphasized a more case-by-case approach.
So the law is acknowledging that sometimes you can't just stick to, a strict formula.
Exactly. It's fascinating how the law adapts to these real-life situations, right? But let's not forget that even if a duty of care exists, it still has to be breached for a negligence claim to actually succeed. And that brings us to the reasonable person test.
The reasonable person, I'm picturing like someone strolling down the street, just being perfectly average in every way. But this is more of a legal concept, right?
It is. It's a legal concept. The court isn't concerned with the defendant's, personal intentions or what they believed was reasonable. It's about comparing their actions to this objective standard, the mythical, reasonable person.
So even if I think I'm doing the right thing, if my actions don't meet this reasonable person standard, I could still be in trouble.
That's the idea. It's a tough standard, but it's designed to protect people from harm and to ensure that those who act carelessly are held accountable.
Okay, so we've covered duty of care and this general idea of a reasonable person, but I'm guessing things get a little more complicated when you factor in, people's different skills, their limitations. Like, what about a learner driver? Or a doctor? Or even kids?
Yeah, you're spot on. There are some fascinating exceptions and adjustments to the reasonable person standard, and that's what we'll talk about next.
Okay, so let's unpack these exceptions to the reasonable person standard. Let's start with underskilled defendants. I'm thinking about a learner driver, someone who's still learning. A case that comes to mind is Nettleship v. Weston.
Yes. In Nettleship v. Weston, a learner driver, Mrs. Weston, was taking a driving lesson, and she lost control of the car. Her instructor, Mr. Nettleship, was injured, and the court actually found her liable, responsible for the accident.
Now, that might seem kind of harsh. I mean, she was learning.
It does seem a little unfair at first glance, but the court's reasoning was that holding learners to a lower standard would create way too much risk for everyone else on the road. It's about protecting the public.
So even though she was inexperienced, she was still expected to drive like a reasonably competent driver would. It's about making sure, that everyone on the road can trust that others are driving safely with a certain level of competence.
Exactly. And this principle doesn't just apply to driving. It applies to anyone who's undertaking a task that requires a certain level of skill, even if they're still learning.
Okay, so if I decide to rewire my house, with zero electrical experience and I cause a fire, I can't just say, oh, well, I didn't know any better.
Right, exactly. You're expected to either get the skills necessary or be extremely careful, right? Knowing the risks. Ignorance is not a valid excuse.
That makes sense. Now let's go the other way. What if the defendant has special skills, expertise, like a doctor or a lawyer? Are they held to a higher standard?
Oh, absolutely.
Yeah.
Absolutely. So in these cases, the reasonable person becomes a reasonable professional. The case of Bolam v. Friend Hospital Management Committee really established this principle. So professionals are judged against the standard of their peers.
So we're not expecting perfection from a doctor, but we're expecting them to act how a reasonable doctor would act, given the same circumstances. We're trusting them to use their professional judgment.
Right. But this can get even more complicated, right? When there are differing opinions, within a profession about what's the best course of action. So there's a case, Bolito v. City and Hackney Health Authority, that kind of address this. And it basically clarified that even if a common medical practice is shown to be flawed, a doctor could still be liable if their actions fall short of that reasonable standard of care.
So just blindly following what everyone else is doing, that's not enough. A professional needs to be able to justify their decisions and demonstrate that they were acting reasonably based on the information they had.
Yes, exactly. Now, let's move on to another important exception. Children. I mean, it wouldn't be fair to hold a child to the same standard as an adult, right?
Definitely not. I mean, kids are still developing, their understanding of the world and the consequences of their actions.
Precisely. The law recognizes this and applies the standard of a reasonable child of the same age. And a couple of classic cases, both involving playground incidents, illustrate this really well. Mullen v. Richards and Orchard v. Lee.
Okay, playground mishaps. I'm all ears. What happened in Mullen v. Richards?
So in Mullen v. Richards, there were these two 15-year-old girls, and they were kind of play fighting with plastic rulers, just messing around. And one of the rulers snapped, and a piece of it flew up and caused an eye injury to one of the girls. And the court actually found that they weren't liable because, they were acting in a way that was typical for 15-year-olds.
So it was just like a little bit of harmless fun that went wrong. And the court understood that children don't always understand or foresee the consequences of their actions like adults do. Okay, what about Orchard v. Lee? What happened there?
So in Orchard v. Lee, we have a 13-year-old boy who was playing tag on the playground. He collided with the playground supervisor, and she fell and injured herself. And again, the court said, well, his actions were in line with how a reasonable 13-year-old would behave during a game of tag.
So in both cases, the court really considered the kids' age, their developmental stage. They weren't held to this adult standard.
Exactly. Now, even with all these adjustments and exceptions, right, figuring out whether a duty of care was actually breached can still be really tricky. The courts have to weigh different factors. You know, it's kind of like a balancing act to reach a fair judgment.
Okay, so what are some of the things they take into account when they're deciding if someone was actually negligent?
Well, one really key factor is the likelihood of harm. So how probable was it that the defendant's actions would actually lead to someone getting hurt?
So, like, if I'm juggling chainsaws in a crowded room, the likelihood of harm is very high, and I'd be held to a much higher standard of care than if I was, knitting a scarf.
Exactly. Exactly. The courts will look at the inherent risks, of an activity. And two contrasting cases, both involving cricket, actually Bolton v. Stone and Miller v. Jackson, really illustrate this principle.
Cricket cases. It seems like sports often end up in court. What were the main differences between these two?
Okay, so in Bolton v. Stone, a cricket ball was hit out of the grounds, and it struck a woman who was standing on the road outside. And it turned out this had only happened like 6 times in almost 30 years, and no one had ever been hurt before.
Hmm.
So the court said, no, the cricket club isn't liable here because the likelihood of harm was so low.
So even though someone got hurt, the cricket club had taken, reasonable precautions, and the risk was considered pretty acceptable given how rarely something like that happened. What about Miller v. Jackson? Why was the result different?
Well, in Miller v. Jackson, cricket balls were flying out of the ground much more often. It was happening 8 or 9 times a season, and they had actually already caused property damage. So the court did hold the club liable because the likelihood of harm was significantly higher, and they hadn't really done enough to address this foreseeable risk.
So it's not just about whether harm happened, but how likely it was to happen and whether steps were taken to reduce the risk.
Exactly. Now, another crucial factor is the seriousness of the potential harm. So even if the likelihood of something happening is low, if the consequences are really serious, then the defendant might still be considered negligent.
Makes sense. Even a tiny chance of a really bad outcome, that's still something you have to try to prevent, right?
Right. And we see this in the case of Paris v. Stepney Borough Council. A one-eyed garage worker lost sight in his remaining eye after a workplace accident. And the court said that the employer should have provided him with safety goggles, even though the risk of this specific injury was pretty low for most people.
But for this particular worker, the potential harm was much greater. The employer should have taken that into account, taken more precautions. It shows how the reasonable person standard isn't a one-size-fits-all thing, right?
Absolutely. It has to be adjusted to the situation
Yeah.
and consider how serious the consequences could be. Now, let's not forget the practical side of things, right? The cost and the ease of taking precautions also play a role.
Right. I mean, you can't expect someone to bend over backward or spend a fortune to prevent every possible thing that could go wrong. There has to be, like, a balance between safety and practicality.
Exactly. And we have a case, Latimer v. AEC Ltd., that demonstrates this. There was a factory, heavy rain, the floor got slippery. So the employer put sawdust down over most of the floor. But one of the workers slipped on an area that hadn't been treated with sawdust, and he was injured. The court said that the employer had acted reasonably. They had taken steps to try to prevent the risk, and it would have been way too expensive and difficult to make sure absolutely every inch of the floor was covered.
So it's not about being perfect, but taking reasonable steps to lower the risk.
Right, exactly. And finally, the social value of an activity can also be considered. So sometimes a bit of risk is acceptable if the activity is providing a big benefit to society.
So like a firefighter running into a burning building or a medical researcher testing a new treatment, there's a risk, but it's outweighed by the potential good.
Exactly. It's a balancing act, weighing the potential harm against the potential good. And that actually brings us to the last element of negligence, causation. Remember, it's not enough to just show that someone didn't act reasonably. You have to prove that this actually caused the harm in question.
Okay, so we have duty of care, we have breach of duty, now we have causation. Sounds like this is where things get extra tricky.
Yeah, it can definitely get complicated, and we'll pick up there next time.
Okay, so we've covered duty of care and we talked about breach of duty. Now let's tackle that final piece of the negligence puzzle, causation. As you said, it's not enough to show that someone messed up. You have to prove that their actions directly caused the harm.
Exactly. And proving causation, well, it can get surprisingly complex. There are two key aspects to consider: cause in fact and cause in law, which is sometimes called remoteness. Let's start with cause in fact, and this is where the but-for test comes in.
The but-for test sounds simple enough.
It is, in principle. So you ask, but for the defendant's actions, would the harm have occurred? If the answer is no, then you've established cause in fact. A really classic example of this is the case Barnett v. Chelsea in Kensington Hospital Management Committee.
Ah, another medical case. Always fascinating. So what happened?
All right, so a man went to the hospital and he had these really bad stomach pains. The doctor on duty didn't actually examine him and he sent him home. Advised him to see his GP. Sadly, the man died just hours later from arsenic poisoning.
Oh, that's terrible. Sounds like a pretty clear case of negligence. But did the court hold the doctor liable?
This is where it gets interesting. Even though the doctor's actions were definitely below the standard of care, the court actually found that he wasn't liable for the man's death.
Wait a minute. How is that possible? If he had examined the man, properly, surely he would have had a chance.
You would think so, right? But medical experts testified that even if he had received treatment, the poisoning was just too advanced. He would have died no matter what the doctor did.
So the doctor was negligent, but that negligence wasn't the actual cause of the man's death. That but-for test wasn't met.
Exactly. The harm would have happened anyway. It's a good reminder that just proving negligence isn't enough. You have to prove it was the direct cause of the harm. Now let's talk about cause in law, or remoteness. This basically means the harm can't be too far removed, too unforeseeable from the negligent act.
Okay, so let's say I bump into you and you spill your coffee. It's totally foreseeable that you might get a stain. But it's probably not foreseeable that you'd, have this whole chain reaction, trip and fall, break your wrist. That would be too remote a consequence.
A perfect example. And there's a landmark case that illustrates this, the wagon mount, #1. In this case, oil was negligently spilled into Sydney Harbor. It spread to a nearby wharf. Then, sparks from some welding work ignited the oil, and it caused this huge fire.
Okay, spilling the oil was definitely negligent, but was the fire a foreseeable consequence?
That's the big question. At the time, it actually wasn't widely known that oil could ignite on water. So the court said, nope, that fire damage is too remote a consequence, and the defendants weren't held liable for the fire.
Wow. So even though the oil spill set things in motion, that specific type of harm, fire, was considered too unpredictable.
Exactly. Remoteness basically stops us from holding someone responsible for every single consequence that might happen, especially the ones that are totally unforeseen. But of course, there are nuances. There's a case, Hughes v. Lord Advocate, where some children were playing near an unattended manhole. They knocked over a lamp and it caused an explosion. The court actually found the defendant liable.
Hold on, I thought we were talking about remoteness. Why were they held responsible for, an explosion?
Because while the explosion itself was unusual, the type of harm, burns, was foreseeable. It was a paraffin lamp. The explosion was just a variation on the foreseeable risk, you see.
So you don't have to predict the exact chain of events, just the general kind of harm that could happen.
Exactly. And there's another case that supports this. Jolly v. Sutton, London Borough Council. A boat was left abandoned on some council land. A group of teenagers were trying to repair it, and they were injured when it collapsed. And the court held the council liable.
So even though the kids were trying to fix it and not just, messing around, the court said, well, that injury was still foreseeable?
Yeah, because the council knew the boat was attractive, but also dangerous, especially to children. So the specific activity repairing it didn't negate the foreseeable risk of harm from a, rundown boat.
Wow, so many layers to figuring out causation. It all comes back to foreseeability and what a reasonable person could anticipate. It's amazing how these cases, really help us understand negligence.
It is, and I think it highlights the fact that negligence law isn't about punishing people for every little mistake they make. It's about figuring out who's responsible for harm when that harm could have been prevented.
It's always evolving, right?
Yeah.
To keep up with new situations and ensure fairness.
This deep dive has been awesome. We went from snails and ginger beer to playgrounds and oil fires, all to really understand negligence. I feel like I've learned so much.
Me too. It's been great chatting with you. And to our listeners, remember, negligence law is all around us. It shapes how we interact, it defines our responsibilities, and it really helps us make sense of a world where accidents happen. Understanding it helps us make better choices and maybe even avoid some legal headaches down the road. Couldn't have said it better myself. Thanks to your expertise, I think we're all walking away with a much better grasp of negligence. Thanks for being here. And until next time, stay curious and keep diving deep.